Hello, welcome to the Fearless Floyd Show. As always, I am your host, Fearless Floyd. Today I'm going to cover my writ of habeas corpus, ground of error number one, jurisdictional defect due to the savings clause. Most of you are not going to want to watch this video, so if you're not into legalese or to challenge a criminal conviction via state writ of habeas corpus, uh, go ahead and tune out now. This is going to be tedious, boring, and just that is what it is. So, sorry about that. All right. Let me get over here and pull up where we need to be. Let's see. Which one is this? This one? File type. Here we go. Now, for those of you who have not been paying attention, this is just my brief. This doesn't include my appendix of exhibits, which is larger than this. This doesn't even include the application. This is just the brief. And that's the beginning of it. And you see right there the filing date, February 2nd. So this is the real deal, folks. And every one of those orange tabs is a ground of error. There's 95 of them. Now let me show you how this thing's put together. It's easier if I take them out of the binder. There's page 1, right? There's page 2. Has all the lists of parties. Table of contents. And this goes through all 95 grounds of error, and I don't have to show you all those. I will show you the last page of the table of contents. So every time you see a page number right there, you can go to that page and you're going to find it. So list of authorities. Now, these right here, these are all from, at the time, there were only 14 courts of appeals. Now there are 15, but these are the Texas courts of appeals. All these cases are in alphabetical order. Those are just from the courts of appeals. I did mine. A lot of people will lump the Court of Appeals, Texas Court of Criminal Appeals, Texas Supreme Court, all under state. I broke them down by jurisdiction for the court. There's some more courts of appeals, and then it goes down to the Court of Criminal Appeals sightings. And they're you know, like pages and pages and pages and pages of this. So, you know, those are courts of appeals. There's the tail end of the courts of appeals. Then I go into Texas Supreme Court. Then that's probably the district courts of appeals, which is the federal level. Then next up was the Circuit Court of Appeals. So that would be the U.S. Courts of Appeals, Fifth Circuit mostly. Like that. That's all federal. Now we get into the Supreme Court. It took me 3.5 months every day, all day, to type this on an electric typewriter in my cell. Absolutely. I remember doing it. And it did re-traumatize me. So there we go to the end of the Supreme Court cases, sightings, and then we break it down to Texas codes, and again, alphabetized. So first one's Code of Criminal Procedure. Then go to the United States Code of Criminal Procedure, Texas government codes, Texas penal codes, Texas transportation codes, rules of appellate procedure, rules of civil procedure, rules of evidence. Those are all state. Texas Constitution, United States Constitution. Now, this is where people run it. This is where I see the greatest errors when people start arguing points. Okay. You see these other jurisdictions, okay, other legal volumes and tomes. All right. Now, I'm in Texas. I cannot use the Colorado state law as any type of jurisdictional authority here in Texas. I can use it as a referral. It's like, hey, this is what they're doing over in Colorado, guys. Maybe y'all should pay attention and listen. So, other legal jurisdictions, I have Tennessee, Delaware, the Western District of New York, the District of New Mexico, Arkansas Appellate Court. Those are probably all DWI cases. Other legal jurisdictions, United States, Alabama Code Annotated, Arkansas, California, Colorado, Connecticut, Florida, Georgia. So those hold no authority, but I can use them as a reference to enforce my arguments and authorities. Other legal publications. American Heritage Dictionary of the English Language, Black's Law Dictionary, 7th edition, Black's Law, 8th edition, because they have different meanings. Code of Judicial Conduct, Commentaries on the Law of England, Donald Purdy and Goldsmith, Better Do Your Homework, Plea Bargaining Under the New Federal Sentencing Guidelines, Dix Dawson, Criminal Practice and Procedure, Lefebvre Scott, Criminal Law, Memorandum, Christopher H. Wray, U.S. Assistant Attorney General for the Department of Justice. Christopher Wray, you heard that name lately? McCormick, Evidence Volume, Nolo Press, Legal Research, Opinion, Texas Attorney General, Sir Francis Bacon, Truth from 1612. 16 Texas Jurisprudence, 3rd edition, Courts, State Bar Rules, Stunts, Plea Bargaining and Criminal Laws, Disappearing Shadow, Texas Department of Public Safety versus Floyd Pleasant Tarvin. That was my ALR hearing. Texas Lawyers Creed, A Mandate for Professionalism. Vincent Alexander, The Hearsay Exception for Public Records in Federal Criminal Trials. Lefebvre and Israel, Criminal Procedure, Webster's 9th New Collegiate Dictionary, Weinstein and Berger, Weinstein's Evidence, West Texas Statutes and Codes, Wright and Graham, Federal Practice and Procedure. I did a lot of reading. I told y'all I did. Okay. These are my cases. And this is how you break it all down. This is how you create a brief and put everything in here so everybody can follow exactly what you're talking about. I'll put the little notes down here at the bottom for abbreviations throughout the book. So here we go. We dive into an introduction before we get to groundwork. Here's a statement of the case. And then we get for grounds for relief, ground 1, and then it goes into all the way to ground 95. This brief, when I submitted it with the application to the Court of Criminal Appeals, it sat in Harris County. Harris County refused to send it to the Court of Criminal Appeals like they're mandated by law. Once it eventually got there in June, by August, they had read it. They remanded it back for evidentiary hearing to find facts, conclude law for my issue of ineffective assistance of counsel for my trial counsel. My trial judge, Mark Kent Ellis, who's a sorry piece of shit. He's a fucking serial criminal. I said that. Prove me wrong. Absolutely. I stand by everything I say. I will back it up in a court of law where everybody will uphold their oath to the Constitution, state and federal. Otherwise, nobody's going to win. So, Mark Kent Ellis. Yeah, he's just a flat out criminal. That's why he's not a judge anymore. He followed his father's footsteps. His dad was a former district judge here in Harris County, and then he went to law school, became a prosecutor, because when you suck at law, you were below average in law school, you become a prosecutor, or you become a pro bono attorney for, the state, where you represent the indigent. So you're just like another arm of the prosecution, because you aren't solicited by the big good law firms that are looking for the brightest and the best. So this is what Ellis did. He went and became a DA, and then because of his dad's name, he ran for office and won. But he got elected out. And he's a criminal. He's a bigger criminal than I am, and that's saying a lot, because I used to be a fucking fool. So at the very back of this, I do my argument. For those of you who don't know, my arresting police officer from the Houston Police Department was terminated for downloading nude photos of one of his DWI suspects off of her device onto his device, and then showed up at her court proceeding and was showing her nude photos on his device to court personnel. He didn't get fired for that. Nobody really held him accountable for that, but he eventually did get fired. And he, like they do, they go join another police department agency, and they're still a cop. But the cop who also lied on the stand, where he said I did field sobriety test after I refused every field sobriety test at the scene. My police report says so. I refused a breath test. I refused a blood test. So I was arrested on suspicion of driving while intoxicated. I was transferred to Central Intox to Officer Russell Rudy, who is passed away. And there's another serial criminal, another piece of shit, a lying dog. Absolutely. And I put that in his obituary to let his friends and family know what a piece of shit they honored. Absolutely. I stand behind all of that. So Green, my arresting officer, transfers me over to Russell Rudy at Central Intox at 61 Reasoner Street. I'm on fucking video. I refuse to participate in motor skills tests on the advice of my attorney. Who's your attorney? Larry Longer. Okay. And then, after I refused everything at the scene, driven downtown, on video refusing it, man, I finally broke down and succumbed that I was going to just somehow, after I signed the DIC 23, 24, 25, acknowledging that my license had been suspended because I refused to give a breath test, that now I'm going to do a field sobriety test to get out of this situation. How much reason does that make? It's a 100% fabricated lie. Falsification of evidence, testimony, tampering with, fabricating a physical record, tampering with a governmental record. That's a crime. When you hand me a document, that's it. You're not supposed to deface that document. You definitely cannot deface that document and present it in a court of law as a bona fide legal document, because it's been tampered with. It's not original. But all that just flew right by. So in here is a pro se waiver that I did. And I'm going to read this to you because everybody should use it. Petitioner implores upon the court to excuse his technical errors and acts sua sponte to protect his rights in keeping with the spirit of petitioner's lack of legal education and a layman's knowledge and understanding of the intricacies of Texas criminal laws, rules, and procedures, and appeals to the court to construe the briefing rules liberally on petitioner's behalf. Petitioner proceeding as a pro se litigant, quote, must be ensured meaningful access to the courts, close quote. That's Rand versus Rowland. That's out of the Ninth Circuit of Appeals. And, quote, is allowed some degree of flexibility in pleading his action, close quote. Rogoslawski versus Kaplan, that's out of the Second Court of Appeals, and should be, quote, construed liberally and held to a less stringent standard than formal pleadings drafted by lawyers. If court can reasonably read pleadings to state a valid claim on which litigation could prevail, it should do so despite failure to cite proper legal authorities, confusion of legal theories, poor syntax and sentence construction, or litigants' unfamiliarity with pleading requirements, close quote. See McCormick versus City of Chicago, Seventh Circuit Court of Appeals, Bogue versus McDougal, United States Supreme Court, and Hayes versus Kerner, again, United States Supreme Court. So there's your pro se waiver. And you could also include Ferretta versus California, which gives you the right to represent yourself without counsel. But you have to have what's called the Ferretta admonishment. The court has to admonish you, which means instruct you to make sure you comprehend that you are voluntarily, intentionally, and knowingly waiving your rights to counsel to represent yourself, which the judge is going to tell you is the worst decision you can make. That's your Ferretta admonishment. Did that teach you something? Hopefully. So anyway, got a prayer right there. And I have my declaration right there. And then, of course, my certificate of service. And believe me, folks, when there's fraud and corruption when it comes to any type of judicial proceeding, it is very difficult to win, to prevail, to overcome, simply because there are no rules. You're playing by the rules, and they're not. You're reading the rules, you're following the rules, and they're not. And this is the problem. There's no accountability within the judicial system. The state bar does not hold the attorneys accountable. I have filed many state bar complaints here in Texas, and I didn't have a bar number. I had a prison warehouse ID number. Wrong number. So I'm going to dive into every one of these day by day. Actually, Juan was supposed to come by. Said he'd be here in 30 minutes. It's been at least an hour. But he'll be here in a minute. And I don't know what we're going to talk about. But I'm going to keep diving into this. I'll finish this out. I will probably cover it more tomorrow, because I have, several different printouts. I have to go back to my original writ of habeas corpus, and if there's any authorities or arguments regarding this error, and I did not bring up the savings clause. I knew about it, I read it, and I just really didn't click. Like, oh, well, you need to go back to that. This is one of the things that AI presented to me when I did use AI. I don't use AI for legal work anymore, because the more I used AI, this is ChatGPT 5, the paid subscription, the more I kept trying to utilize it to refine what I was doing, it got worse and worse and worse, and started misciting stuff that it obviously had known. It was condensing everything. I was like, well, I wanted you to expand that, not condense it. And it just ended up being a total loss, a complete waste of time, money, and energy that I dedicated, probably 2 months to playing around with it. And I got to the point where I'm not gonna sit here and play this game with stupid artificial intelligence. I'd rather do this myself. I have all the materials here. I have everything I need. I have my complete trial record. The slowness for me is having, and I tell everybody this, please do not muddy up your record. And I'm getting ready to define exactly what that looks like. Okay. Because I had to fight so hard to get my case to be heard. And then once I thought it was going to be heard, I'm like, okay, cool. Now I can go back to Harris County. I'm going to be bench warranted back. I'm going to go for my hearing, and I'm going to be able to go to court and open this can of worms up and show the world and go, here, look, everybody. Because not only does the savings clause do what I said it would do earlier in this video, but when it comes to commission date, and this is what happened. There's an entity called the Texas District and County Attorneys Association. That's all the county attorneys and district attorneys. And they have their own association. Well, in those, they create manuals, materials for their prosecutors, their district attorneys' offices as templates to use. So the original template that was produced by the Texas County and District Attorneys Association was created insufficiently to allege a third-degree felony DWI. It only alleged the 2 prior convictions. It never alleged the commission date of the intervening DWI to allow enhancement to a felony. I've read dozens of felony DWI indictments, all prior to 2005, September 1st. Not one indictment that I've ever read as a felony indictment has been properly pled to plead a third-degree felony under any statute. Period. 0. Which tells me every felony DWI conviction from August 31st, 2005, all the way to September 1st, 1994, are void ab initio at the beginning because they were never pled as a third-degree felony. You see what I'm saying? We're talking hundreds of thousands here. You think Texas is going to do that? You think they're going to allow me to prevail? You think they're going to publish this? This is what I'm up against, folks. This is what I've been doing. My entire legal career is finding these loop barn doors, basically what they are, that have been left wide open and nobody's pursuing it. Nobody recognizes it. Nobody addresses it. Nobody confronts it. Here I am. That's why I'm doing these videos. I want this to be public. I want this to be known. They need to know that we know that they know, and they're not doing what they're supposed to do. So I'm getting ready to go back into trial court. I've already befriended one of the clerks for the post-conviction division down here in Harris County. Broke it off to him. And you hear me speak, so you know I know what I'm talking about. I can just spit this shit out. It's second nature. It's another language. And this is where we're at. Absolutely. Another thing that I haven't even brought up. If you go read the felony DWI statute, it says you having lost your mental or physical faculties. So there's a choice, right? Disjunctive, not conjunctive. And I'm no English major, but I know the difference. So you got a jury of 12 people, right? You're presenting your evidence. Now you go for a adjudication with the jury to determine guilt or innocence. So what did they actually convict you on, Floyd? Did they convict you that you lost your mental faculties, your physical faculties, or both? Now you have a mixed verdict. That don't work either. No. How many felony convictions have been convicted like that took it to trial? Because if you plea bargained out, you sold yourself short. That's why I tell you, folks, I've been through a felony trial where the minimum punishment was 25 fucking years in prison. That was the minimum I could get. Minimum. State asked for 35. Court gave me 60. There you have it, folks. Tied up. We're going to cover some more of these errors. Let's see if I can find. Forgive me, I have paperwork everywhere. I mean, literally everywhere. I'm looking for the grounds of error. I think this is it. Run down. That's what I do every day. I just got way too much stuff. I'm printing this stuff out, tearing it up, throwing it away so I don't get confused and doubled up. No. What did I do with the brief? Not there, not there, not there, not there, not there. I went through this. Could be. Basically, I can't find it. Three jurisdictional defects: the saving clause, the commission date, the ex parte amendment hearing. So those are three jurisdictional defects right off the bat. Ineffective assistance of counsel, prosecutorial misconduct, judicial misconduct on my trial judge and proceeding judge, because the state, the prosecution, during trial, when my attorney, I made him like, dude, object. Object to what? He's talking about I took some test. I never took any test. Are you sure you didn't take any test? No, I didn't take any tests. Object. Object, Your Honor. On what grounds? According to my client, he never took this test. He didn't even know what test we're talking about. Prosecution. Well, Your Honor, if Mr. Wilhite would have looked in the state's file, and they have an open file policy, which means at the beginning of all proceedings, the file's laying right there on the desk for the attorney to come up, open up, and read. If he would have opened the state's file, he would have known that this officer would have testimony of this nature. And if he didn't do his job. And at closing, my dumbass attorney, who's now disbarred, stated to the jury, I was shocked because I didn't even know about the HGN test. You were shocked? Well, that's the fucking holding all the courts used. It must shock the conscience. It was so pervasive. It was such an error of constitutional magnitude that it shocks the conscience. Well, that's in the record, folks. This is what I've been up against. From day fucking one of my trial, all the litigation I did, bigger cells, climate control, which means air conditioning in the prisons. At the time, Texas prison, the Texas penal system was the last penal institution. The last penal institution in South America, Central America, Mexico, and North America to install pay telephones for their prisoners. That includes Mexico, every county jail, every city jail, every state, federal, and territorial penal institution. Texas was dead last. So we filed a lawsuit. Wow. A lawsuit gets dismissed for failure to state a claim for which relief may be granted under 12 Rule B6. Texas legislator gave us payphones. Absolutely. Hang on one second. Yes, sir. What's up? No. Maybe. Whenever. I don't know. Juan's he should have already been here. I don't know where he's at, but he's on his way over, my filmmaker buddy. So as soon as he gets here, I'm polishing up on a live. I'm just sitting here doing my legal work. So whenever. Okay. Yeah, that should be fine. I don't see any issues. Okay.
I don't know if he has a half, a full half, but just in case, is there another one on there you want to get like a QTO?
Yeah, I'll look.
Check and let me know.
Okay, I will.
I'll hit you up in a little bit, and then hey, one more thing too. So
Mm-hmm.
I got you money for I forget how much it is. I know it's for 3 ounces.
Okay.
I'll do the math on it, but I got you.
Okay, cool. Yeah, we'll put it all together. All right. Bye. All righty. Here's another thing. All right. I went. It's in black and white, folks. I can't make this up. Right here, you see this letter here. Okay. It's from Gwen Moore, who was the post-conviction clerk for the Harris County District Clerk's Office. And, I'm going to read it to you. This is from February 1st, 2006, because I filed my writ of habeas corpus January 30th. Actually, I filed it before that, but they received it January 30th, file stamped it. She generated this letter, sent it to me. And it says, "Dear applicant, your post-conviction application for writ of habeas corpus was received and filed on January 12th, 2006. Article 1107 of the Texas Code of Criminal Procedure affords the state 15 days in which to answer the application after having been served with said application. After the 15 days allowed the state to answer the application, the court has 20 days in which it may order the designation of issues to be resolved, if any. If the court has not entered an order designating issues to be resolved within 35 days after the state having been served with the application will be forwarded to the Court of Criminal Appeals for their consideration pursuant to Article 1107, Section 3, lowercase c of the Texas Code of Criminal Procedure." And who got CC'd? The judge of the court. You flip it on the other side, the next entry is the district attorney's acknowledgement of receipt of the application. So this was February 1st, right? February 1st, but they received it on the 12th of January. This is dated with a rubber stamp, February 13th, with a rubber stamp signature, which is totally legal in the state of Texas. You can use facsimile signatures. They have all legal authority, according to the Texas Supreme Court. Why? Because back in the late 70s and early 80s, the grand juries were rubber stamping the indictments. It got challenged. People were being released on that technicality, and the Texas Supreme Court closed that loophole. Okay. So it says filing date 1/12/06. Dear sir, I hereby acknowledge receipt of a copy of the above captioned post-conviction petition for writ of habeas corpus filed pursuant to Article 1107 Texas Code of Criminal Procedure. Therefore, I waive service by certified mail and provided therein. I understand that I have 15 days in which to answer, which means it's due by February 28th, right? This right here is their motion requesting designation of an issue. This document was filed February 28th. It was filed. It's a motion. It's not an answer. It's just a motion. It's a request. It's a favor. Hey, Judge, can you do me a favor here? That judge held 2 hearings on my motions, never once adjudicated this motion. You want to know when he did? 2009. Yeah, we're talking 2006, 2009. So in between that gap, I'm filing writs of mandamus after mandamus after mandamus after mandamus after mandamus. This was originally, my number was 17817, which is my permanent writ of habeas writ number for the Court of Criminal Appeals. But they just put a hyphen in however many writs you've submitted. So this was actually supposed to be writ number 5, but it wasn't. It eventually became writ number 10. So there are 5 different mandamus proceedings in between my original filing and when this got eventually dismissed. Yeah, this is all the fucking bullshit I've been through with the fucking state of Texas. To tell you that I'm disgusted, appalled with my state, the way it functions, my government, my judiciary, the educational system. It's very difficult for me to talk to these people and not just be a belligerent because of what they're doing, what they do to everybody. It's horrific. And this is the bullshit they do. They don't follow the law. They don't care what the law says. Rubber stamp. You're going to rubber stamp something? Hold on. Let's see. I mailed this at the beginning of January. It took several days for it to get to Huntsville, Texas, to Houston, Texas. And that's 90 miles. But yet to go one city block downtown, it took a whole month. From the 12th of January to the 13th of February. Really? And then you want to use a rubber stamp? You see how pervasive the fraud and corruption are? How depraved these people really are? There's no accountability, no honor, no integrity, no good faith, no clean hands. These people are dirty as sin, if not worse. These people are evil. They have an evil system, and they perpetrate it. And they think they're doing righteous work when they're some of the most evil people on the face of the planet. They're human traffickers. They traffic humans. They relish in the fear, the lonesomeness or loathsomeness of people, the suffering, not just to the defendant, but to the defendant's family, their coworkers, their community. They don't care. It's all about a notch in their belt. How many convictions do I have? How much time did I get out this year? No. The fundamental principle of a prosecutor is to seek justice over a conviction. And those tables have been turned because now it's up to you to prove you're innocent because they've already had you guilty. Just because they went and got a little old complaint and they got a little old information or indictment, you're guilty. Now prove you're innocent. That's why over 90% of all criminal offenses are pled out and plea bargained. If everybody took that shit to trial, they'd be dismissing 80% of them. They don't have enough judges. They don't have enough personnel. They don't have enough money. They don't have enough prosecutors. They don't have enough investigators. But you people want to fucking be convenient. You're going to surrender your humanity for convenience to AI, and then you're going to really suffer. We cannot let these people prevail. We cannot let these people govern. These people are criminals, serial criminals, where they all go meet in a bar and drink and cut it up about what all they've done in the legal realm. Proud of themselves for what they've done. Think they've really accomplished something. Think they've really cleaned up the streets. Well, you haven't done jack shit. You want to clean up the streets, go out here and become a cop. Don't sit there and go clean up the cops' mess because that's all you're doing because the cops are so understaffed, overworked, underpaid, underappreciated. And yes, for those of you who follow the constitutions, follow your oath of office, you always operate in honor, integrity, good faith, clean hands. I'm right there with you. I support you. I'll always support you. But for those bad apples who want to lie on the stand, lie to get a conviction, bend the rules, don't give a fuck about the Constitution, definitely don't give a fuck about their oath of offices, don't even understand what they just swore to, refuse to read, study the law. It's a travesty. And this isn't just Texas. This isn't just me. This isn't just Harris County. This is pervasive on every level in every jurisdiction across this country. And until you educate yourself about the law, you're always going to get run over. You're going to have to hire this hired gun that you expect to come in there as a gunslinger and clean house and execute everybody so you can walk out a free man. Nope, they're part of the cabal. That's their job, to stay within the confines of the bar machinations, which means their sandbox, their playground, their toys. Don't bring your shit to their sandbox, their toys, because they're not going to play with it. And they're going to have consequences and repercussions for you bringing that bullshit into their game. Just like you running your own game and they're trying to come in here and bring their bullshit in here. You're like, yeah, we don't play that shit. Get the fucking shit out of here. Bump it on down. Next. This is what you're up against, folks. Get educated. This is what I call the people that are going to be enlightened or are enlightened. We're not awake. We're not woke. We're enlightened, which means we have a brighter future. And it's up to you to make it a bright future for yourself, your community, and your loved ones, your friends and family. If you think the political machinations are going to save you and make you free, you're a slave. You've been programmed, institutionalized, dumbed down, miseducated every day of your life, and you're going to continue to stay that way. I've sit here and I've just shown you one ground of error. My bullshit that I've been through, what these people have done to me, suppressed me, violated my rights left and freaking right, committed felonies to shut me up and shut me down. Change state law behind me. Change prison policies behind me. Because what do? I go find out what the truth is, and when I tell them what the truth is, they don't want to hear it. Oh, no. He can't be right. We're going to change the law. We're going to go change the policies so he can't be right. I'm not here to stick feathers in my cap and go, oh, look at me. Look what I did. No. I'm here to express to you what you need to do for yourself, for your family, for your friends. So you don't have to go through all the bullshit that I've been through. Because believe me, these people put me through some bullshit. If you think you can type a 350-page brief like this with index of authorities, table of contents, everything, where you just read a number, page number, you go to that page number, and you're going to find that citing, where it took me 3.5 months, every waking minute of my day for 3.5 months, this is what I did. All I focused on. I don't think I could do it today out here in the world with all the distractions, but this is what I did. That's what I accomplished. And that's just one piece of my many litigations. You should see what I did for my misdemeanor DWI for that 1987 DWI when I challenged it on a writ of habeas corpus. Because if you listened carefully, this is challenged under 1107, right, of the Texas Code of Criminal Procedure. That's just a procedure for a writ of habeas corpus filing. The actual governing authority to allow you to challenge a felony conviction by a writ of habeas corpus is 1108. The procedure to challenge a misdemeanor conviction by writ of habeas corpus is 1109. Okay, well, what's the procedure for that? There's not one. You would think it'd be 1110. It's not. There isn't. So when I challenged this, the judge just created his own framework. No, that's not how it works in law. Law, when there's no procedure for a law, you have to go find the closest harmonizing statute to the intent, the legislative intent. So all you have to do is go from 1109 to 1107. Just two subsections, and find the procedure and adopt it. I went so far as to write the chair of the Criminal Justice Committee for the Texas Senate, who at the time was our new mayor for the city of Houston, John Whitmire. Wrote that fool repeatedly to try to get him to draft a bill to establish the procedure for a misdemeanor writ of habeas corpus challenge. Absolutely. I'm the only one that's probably ever done that. I'm probably the only one that's ever recognized it. I'm probably the only one that's ever done that. And in that proceeding, do you know what my appeal bond was for a 30-year-old DWI in which I was sentenced to 30 days in jail and had a $100 fine, which completed way back in 1987? My appeal bond set in 2000, I don't know, was it 6 or 7, by Judge J. Carahan, $1 million. Absolutely. And after multiple motions to reduce the bond, mandamuses to the courts of appeal, eventually it got reduced to $250,000. And during that proceeding, Judge J. Carahan was ordered by the First Court of Appeals, Judge Tim Taft, to conduct an evidentiary hearing. And in that evidentiary hearing, Judge Carahan put out a finding of fact, conclusions of law regarding my writ. And in that, and I'm paraphrasing, but I'm almost word for word accurate, documents filed into the Harris County Criminal Courts at Law Clerk's Office were often found stuffed in drawers, on shelves, and places other than the files in which they belong. He put that in the public, folks. Absolutely. That's what we're dealing with here. Fraud and corruption, every nook and cranny, every rock you kick over, there's a dirty dealing dog underneath there with a government title. And I could sit here and go on and on and on and on about almost every one of my litigations. Yeah. How can a U.S. District Court judge tell me that we're frivolous and malicious for failure to state a claim for which relief may be granted under Federal Rules of Civil Procedure 12b-6? When the Texas legislature just gave us collect payphones? How did we not state a claim for which relief may be granted? Because that's a corrupt federal judge. They don't apply law. This is what we're up against. This is what I've been up against the entire fucking time. It's appalling. It made me stop litigating after a 12-year career where I was winning. Everything I was produced was a winner, but they were not going to let me win at all costs, even if they had to go to change a state law behind me. Why? It would open the door for 70,000 convicted felons in Texas prison system to be able to use this particular Texas Health and Safety Code remedy by filing a writ of habeas corpus for emergency protective custody for chemical dependency treatment into their county of conviction, be bench warranted back for chemical dependency treatment, because the only way you can get chemical dependency treatment in the Texas prison system is if and when you are granted parole and the parole board assigns you what kind of substance abuse treatment you will have. So if you're doing a 10-year sentence aggravated for possession of 20 pounds of methamphetamine, you're doing 5 years flat before you even talk to anybody about parole, before you even think about getting chemical dependency treatment. So had I prevailed on that, it would have allowed 70,000 offenders who acknowledged upon their entry into the Texas penal system that they had a substance abuse treatment at the time of their offense. Logistically, economically untenable for every county and the state to do that. It would have emptied out the prisons. It would have overloaded the county jails. So how did they remedy that? They couldn't defeat me in black and white. They went and changed the law and applied the new law to my case, even though it is what, folks? What did I tell you? The law of the land, the offense date, the commission date is what governs. So theoretically, so I got Juan coming up. I got some other stuff to do. I need to get back to work on this. Thank you, everybody, for spending your time with me. I really do appreciate it. I hope you learned something. I hope you got educated. I will continue to do these series. So just look for that thumbnail, the 2001 DWI, and we will discuss this. Let me go over here to the comments and questions. No volume. Are you serious? Well, obviously, you're hearing me now. I don't know what's going on with the volume. It's nothing on my end, nothing I can see. Like I said, Streamyard has been having some issues this last week. Every time I upload it, sometimes when I'm brand new, I'm fragmented, I'm buffering. So I don't know what's going on with Streamyard. I can send them a notice or whatever for customer service, but it's going to take them 2 or 3 days to even reply to that. That's what I hate about StreamYard. I cannot stand companies that do not have a person on the other end to find solutions to issues that people have. And, I could use another one, but I just don't have time. That's it. I'm out of time. So hopefully you've heard the entire thing, and you can catch it on a replay. So stay tuned. I'll be trying to do these every day. Hopefully I'll get to you earlier tomorrow. So stay tuned. What do I got coming up? I don't have any shows scheduled for this week, but I may do some one-offs. I definitely want to get the Mushroom Ladies back on. But not this coming Wednesday, next Wednesday on the 29th, I will have Daryl James, a super soldier, 8 p.m. Wednesday. Looking forward to that show. I've never had a super soldier, so tune in for that. And that's all I have. So thank you, everybody. I really appreciate it. Got that 2-minute outro coming up, so you don't want to watch that. Burn off now. Thank you, everybody. Y'all have a God-blessed week.
I come through with the style that's always revealing, from the block like the TikTok don't stop. I was at Shorty, she was non-stop. I had the hot clot, chilling like a real god. Everybody know Big Juan was a show shot. You get high with the Don, here's the real supply. You get high with the Don, here's the real supply. It goes on, ain't no fucking questions why. The gangster of love, get the real fucking supply. What? She came through, giving me more than I can tell you. Everybody knows the next level, I'm so clever. Take the day off. Take the day off. Yeah. Get high on your own supply. Feel like a dime when you do or die. Just get high on my own supply. Do or die when I'm feeling like why. Choose a dime piece. Yes, one of a kind. Other than me, I was one of a kind. We had to build through the shoes to the side. Come on, throw them shoes to the side. Take the day off with me. Come on, take it off with me. Take the day off with me. Take the day off. Get on trap me. Trapping with my friend right here. That's what I say. The best. Say Jacks, they ending up to nothing. Everybody loves it with me. Okay, yeah. When mom cut off your welfare, I was there. Holding you down, mama. Holding you down. When it left you alone, I was there. Everybody knows I was there. You wanna call me out now? Still loving you like I'm loving the sound. Yes, I still be there. Them found ass niggas ain't here right now. Who loves you now? And who loves you now? And who loves you now? Take the day off with me. Take the day off with me. Take the day off with me. off. Take the day off. Maybe the whole fuck